Hi, my name is Zachary Mann, and I'm first affirmative. Our claim is that NSA shouldn't be allowed to collect cell phone data. First off, I'd like to start off with a quote by Benjamin Franklin, founding father. He said, "They who can give up essential liberty to obtain temporary safety deserve neither liberty nor safety." The Amendment 4 in the Bill of Rights applies the right to privacy. And then this NSA, it intrudes in our privacy. So, Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This implies privacy, especially with the wording unreasonable searches and seizures. And the collection of cell phone data intrudes in that privacy. Patrick Eddington states from the bipartisan House bill would repeal Patriot Act and ban mass states all mass surveillance does is violate the rights and put a chilling effect on the American people. What the NSA can do is the information they collect includes the phone number dialed, the time and duration of the call, and information about the cell phone tower used to make each call. Also in Amendment 1, also somewhat implies privacy. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise clause thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. I'd also like to bring up 9/11. After 9/11, Congress passed the USA Patriot Act as a response to 9/11. And Patriot Act allowed judicial oversight of these new powers, judicial oversight of these new powers is essentially non-existent. The government must only certify a judge with no need of evidence or proof that such a search meets the statute's broad criteria, and the judge does not even have authority to reject the application. Also, trap and trace searches, it expands another Fourth Amendment exception for spying that collects addressing information about the origin and destination of communications, as opposed to content. Also, the government no longer has to show evidence that the subjects of search orders are an agent of a foreign power, a requirement that previously protected Americans against abuse of this authority. Also, secret searches. It expands the government's ability to search private property without notice of the owner. So your house can be searched and you might not even know about it until after they've searched it. Whereas the law before, you had to be notified that you were about to be searched, and so you could fair or do whatnot. Also, intelligence searches. It expands a narrow exception to the Fourth Amendment that had been created for the collection of foreign intelligence information. So basically, we can spy on other foreign nations, whereas it's illegal over there. Also, record searches, record searches. It expands the government's ability to look at records on individuals' activity being held by third parties. The FBI does not even have to show a reasonable suspicion that records are related to criminal activity, much less the requirement for probable cause that is listed in the Fourth Amendment to the Constitution. All the government needs to do is make a broad assertion that the request is related to ongoing terrorism or foreign intelligence investigation. A person or organization forced to turn over records is prohibited from disclosing the search to anyone. As a result of this gag order, the subjects of surveillance never even find out that the personal records have been examined by the government. That undercuts the important check and balances on this power, the ability of individuals to challenge illegitimate searches. Also under the Patriot Act, PR-TT orders issued by a judge are no longer valid only in that judge's jurisdiction, but can also be made valid anywhere in the United States. So if a judge is, if orders issued by a judge no longer valid in that judge's area, they can also be made valid elsewhere, anywhere in the United States.